next case to come before the court is State versus White. And it looks like the appellant is the only one going to be arguing, so I know you could argue against yourself and do a nice job with that, Mr. Kudichik, but we're not going to give you any rebuttal time. You just have your 15 minutes.
Very well, Your Honor.
And please remember, you've been here many times, but please remember, don't mention the names of victims and don't mention the names of minors. Thank you. You may proceed.
Judge Stevenson, Judge Carr, Judge Lansing. May it please the court, I am Richard Kudichik. I am court-appointed counsel for Jaivion DaMarea White. And you're probably saying, well, what, you're here on a sufficiency case. Come on, this is a run-of-the-mill sufficiency case. Do you really need to talk about it? And if I were to say it's a insufficiency case, that's precisely why we are here. And I think that is demonstrated by the fact that the government decided there's nothing to argue. And the reason for that, they don't have anything to argue. And so when you underline that, you're saying, we say, well, there's really no conflict in evidence here. So when we look at the evidence, we design the concept of sufficiency and manifest weight. So, and I should tell you, I was riding my motorcycle the other day and thinking about this case. Oh, by the way, I'm a Yamaha rider typically, but a year ago I went to visit my friend and he had this red Harley Davidson that he wanted to sell to me, and I said, I don't need a Harley Davidson. I don't want a Harley Davidson. So the next year I went back, he took me out to the garage and he starts up the Harley. And needless to say, my joyride the other day was on the Harley. So the state brought this case as a circumstantial case, and I think that's critical. The state brought this case without a victim, so we have a victimless evidentiary pattern here, and that also is critical. So we have Jaivion and Mr. Victim. They're hanging out together, everything's fine, there's no evidence of a fight, nothing unusual. They're in this apartment building where they stayed, maybe, I don't know, nothing unusual at all. But Jaivion is accused of shooting Mr. Victim. Why? There's no motive, there's no gun, there's no physical evidence, there's no proof of ID of the perp. But Jaivion did it. Well, when I was writing
Mr. Kudichik, is there not a video that purports to show the defendant in this case following the victim? When you say there's no ID, is that not the case in this particular case? Am I thinking of another case we have today?
Well, I think they stipulated that Jaivion was there.
Okay.
I don't think there's any question that Jaivion was there. But that's not the sufficiency basis of proof beyond a reasonable.
Well, actually, you just say there's no ID. I mean, I appreciate there's
no ID.
evidence that he was there. Whether he's a shooter is contested, and whether there's evidence of what you contest of him being the actual shooter.
Yes, Your Honor, and I think that's a critical point. I mean, he was there, but there's no proof he committed the crime. And that's what's so significant about this case. Well, what evidence? There's no physical evidence of residue. There's no DNA. There's no fingerprints.
Isn't there evidence though that there's gunshots heard, and then there's a video at this contemporaneous time of him with a gun in his hand?
Well, you say it's a gun, but here's the other distinction. I'm glad y'all bring that up right away. The gun, well, so we have a PCI expert, a forensic expert, who can't identify the gun. Oh, what about Detective King? Couldn't identify the gun. Oh, what about the eyewitness? Couldn't identify a gun. So what we have in this portrait from the state is, well, he was holding a gun. Maybe he was, maybe he wasn't. So when I'm riding my motorcycle, I'm going, well, wait a minute. Maybe he did it, or he probably did it, or no, he did it. Well, there's no evidence to prove beyond a reasonable doubt. That's what we're here for today. Let's talk about the blood. There's no blood match. So we have no physical evidence. We have no blood match of the victim. So show up. So the guy that gets shot, the state doesn't even, oh, wait a minute, I also wanted to point out, well, the victim did show up because he was said to have made a statement, uncontroverted, that he did not know who shot him. Now, how can that be? If he certainly knows what Jaivion was looking like, they're friends, he certainly knew what Jaivion was wearing, no description. So how could the victim say he didn't know if in fact Jaivion did it? So you might say, or we might say, as the 13th juror that you are, that, well, we didn't have to believe the statement Jaivion made. He might have been afraid, he might have been this, he might have been that. Well, isn't that reasonable doubt still? So I think that is yet just another insufficiency. So we don't have cameras in every part of the building. I think that's also important. And then we take a look at Mr. Nesby. Our maintenance man said, oh, and I think it's also important to take a look at the state's brief there at page 4. What does the state say? Mr. Nesby said they allow a string of various people to live there on and off, including Jaivion and Mr. Victor. But also then we look at, well, what about this window? This window is so critical. There's no evidence that you couldn't get in that window. In fact, the uncontroverted evidence is that you could get in that window. And the other part about it is, and so there's insufficient testimony about this window. I mean, I think that's easy enough to say, isn't it? You know, it's easy enough to have a picture or have somebody testify about it. And most importantly, the testimony of Mr. Nesby is uncontroverted. That's how I went in and out of the window. So that means a string of various people can come and go, and the state does not in any way, they concede that one of the bars was bent and out of alignment. So the window is critical when you look at the failure of evidence or the insufficiency. So we have multiple cameras, but we have no capture. And then we take a look at the investigation. There's no evidence that they canvassed or searched that building for anybody else. There could have been somebody else. So when we look at the evidence that is supposed to suffice for proof beyond a reasonable doubt, well, we have no idea. We have no evidence, physical evidence, and we have an eyewitness who doesn't really see anything. Now he hears gunshots, and he looks out the window. Next thing you know, he sees people in a car driving off. Where's that on the video? That's not what the video shows. The video shows, supposedly, Jaivion chasing after Mr. Victim. Or was he chasing after another perpetrator? Or what was he doing? We don't know that. And that's why you can't really hold on to the testimony of the eyewitness at the Towel building. It looked like a gun, maybe a gun. Can't identify the perp with any clothing or whatnot. What's this eyewitness all about? There's no shooting evidence coming from that witness. And also critical is that there's no shooting going on in the street that we are aware of. So where are the bullets found inside the building? He didn't shoot him in the street. And that's curious to me as well. So he's chasing after Mr. Victim, supposedly. But yet, he doesn't shoot him outside. I mean, if you wanted to shoot him, it just doesn't add up. And that's where the reasonable doubt is so prolific here. Now, it's also critical, the state claims that the casings bore markings that indicated they were fired from the same weapon, which was not recovered. Again, no gun and no identification. So this court, looking at this de novo as the third juror, what does the record show? Does the record states, does the state's evidence, if believed, would it convince the average mind of the defendant's guilt beyond a reasonable doubt? Under what evidence? Under the evidence, well, like you said, well, he was there, so maybe did it, probably did it. So those critical failures on the each element has to be scrutinized by this court. Now, here we are, Monday night quarterbacks. I understand that. But isn't that what sufficiency and manifest is all about? We're reviewing it in the record and how a jury thinks. So we have a gun, we have a victim, and so, I mean, someone's got to pay for that. And the problem of failing in the essential elements, well, we don't even worry about the state's evidence, whether it should be believed, because it's insufficient and it's consistent evidence. It's not conflicting evidence. So when the state talks about, well, you're not here to resolve credibility and so forth, and I would thus ask, well, if the evidence is believed, what does it show? And it does not show that Jaivion pulled the trigger. It sounds like it because he was there, but we don't know if there was another person there. Why isn't the blood matching up? Why isn't the blood trail? Why is the victim saying he didn't know who did it? So when you put all that together, and speaking of evidence, well, the victim's statement. So was it believed? Maybe it wasn't believed. Why? There's no impeachment. There's no cross-examination. There's no showing of lack of credibility. That's what the victim said. So it's a spontaneous remark, excited utterance. Was he making it up because he was afraid or whatnot? Well, who knows? And that's what reasonable doubt is all about. So his remarks are trustworthy. And so the state just didn't produce adequate evidence to carry their burden of persuasion. And the argument from the state is, well, what I say is misplaced, but, you know, Jaivion did it, but is it really? And then when getting back to the gun, well, whose gun was it, even if he was holding a gun? You know, we don't have that connect. So I think when the court takes a look at the totality of this evidence and how you review it as a 13th juror, you're not going to be able to find proof beyond a reasonable doubt in this case. I mean, Mr. Nesby has undisputed testimony about the situation. Read through that. Detective King has undisputed testimony that she didn't, you know, read what she says. Look in my comments in my brief about what Detective King said. Was he carrying anything that you could tell? I couldn't tell. And it looks like, is he waving the gun? I'm sorry, I can't tell. They appear to be conversing, yes. His hands, did they appear to be any argument or problem between the two? No. Did they go outside together? Yes. So if you look at the actual police investigation, they don't have anything that can provide sufficiency of evidence to connect Jaivion to be the actual perpetrator. Remember, beyond a reasonable doubt. And I guess when we look at the forensic scientists backing to that, it's curious that this expert can't come to a conclusion on that. And that certainly is reasonable doubt. So, Your Honors, when we talk about resolving evidentiary conflicts, in this case, there really are none. So you take the evidence, and the state could not prove the identification of the shooter beyond a reasonable doubt. And here's another thing. They couldn't prove that he knowingly did it. So let's say he did it. Let's say Mr. Victim got injured. Well, was it an accident? You know, guns go off. Where's the knowingly content in terms of the state's presentation relative to sufficiency of evidence? So if you take the evidence that is there, if believed, no gun, you can't convince an average jury beyond a reasonable doubt of this man's guilt. And if you look at the government or the state's brief here on page 12, they come up with what they say is the support for this. It says, from this evidence, the reasonable inferences are that DB was unharmed before he entered, and he was harmed after he exited. And the only person in the apartment was there to shoot DB was white. No, that is not the evidence. In conclusion, as the 13th juror, in this case, the jury lost its way here. This is the exceptional case. There's no conflict in evidence. There's not proof beyond a reasonable doubt. There's no conflict shown between Jaivion and Mr. Victim, no proof, no beef, they were getting along. So if the victim doesn't say it was Jaivion, why is there a reason to disbelieve him? It's uncontroverted. The verdict and the conviction in this case must be reversed by this 13th juror. That's the fair thing to do and the right thing to do. Thank your honors for listening to my case on behalf of Jaivion White.
Thank you. We will obviously consider the matter and issue a written opinion that will be sent to the state as well as the appellant. And then we will release it on the Supreme Court website as well, so you can look forward to that. Thank you.
Thank you, Your Honor. I always look forward to your decision.